Well, good morning, Deb. So I'm Kevin Sadler. I'm a partner and trial lawyer at the Baker Botts firm. I've been there for the past 31 years. I have a general commercial type litigation practice. I do cases in state and federal courts across the country. As far as clawback cases, fraudulent transfer cases, that's been a part of my practice really for about the past 13 years. The first large case I was involved in was back in 2008. That was the Asarco versus Americas Mining case. It was multi-billion-dollar fraudulent transfer judgment tried in the bankruptcy system in front of a federal district judge. I think it's still the largest fraudulent transfer judgment in the bankruptcy code. It was for a while. Maybe somebody got ahead of us, but it was the largest for quite a while. But since 2009, I've represented the court-appointed receiver for the Stanford Financial Group, which is a multi-billion-dollar Ponzi scheme, second only in size to Madoff. And in connection with that, over the past 12 years, I've filed dozens and dozens of fraudulent transfer cases against literally hundreds of defendants.
What we want to know is a brief background of this case. I know it's a little bit complicated, but I would start out at the bankruptcy level, and then what happened in the district court, and then what happened in the Court of Appeals.
So this case, of course, starts in the federal district court because Stanford is an equity receivership. We're operating outside of bankruptcy. What I'd like to tell people, because I'm asked all the time, what's the difference between bankruptcy and federal receivership? And I say federal receivership is like bankruptcy, except without all the rules. We just kind of do it. And so there you go. So Stanford starts out in the federal district court, and just a very brief blurb on the Stanford scheme to give the context because it's important here. Alan Stanford ran a worldwide Ponzi scheme for about 20 years through a bunch of different companies, but it all revolved around selling certificates of deposit from a bank he owned down in the Caribbean in Antigua. That was the engine of his fraud. And he promised investors double-digit rates of return. You know, it was all low risk, very liquid, safe. You could get your money out anytime. So a different kind of Ponzi scheme than Madoff. And he sold billions and billions of dollars to these CDs and more than 18,000 victims before the fraud collapsed. He's now serving 110 years in prison. For a time, he was actually in Coleman, the same prison Madoff was. I don't know if they were like bunkmates or something, but they were in the same prison. So
we have a lot to talk about.
Yeah. So as part of the SEC suit that shut down Stanford, and Stanford collapsed just 2 months after Madoff, the U.S. District Court appointed a receiver, my client, and as the lead lawyer for the receiver, I've been leading the asset recovery litigation efforts for the past dozen years. And Magnus, now turning to Magnus, why Magnus? Well, Magnus was the largest U.S. purchaser of these certificates of deposit. He was Stanford's largest U.S. investor. Magnus he's a billionaire based in Colorado, very sophisticated financial person. And in the fall of 2008, Magnus started to get a little nervous about his $80+ million investment in these Stanford CDs. You know, there are a lot of red flags that we presented at trial. But his nervousness rose to a sense of alarm when in October 2008, he went to Stanford and tried to redeem his CDs. And what happened at that time, and this came out of trial, is that the people at the Stanford Bank said, well, you know, the market's kind of in turmoil right now, and we really would rather keep your CDs on our balance sheet, so we can't let you redeem. Now, why is that significant? Well, it's significant because at that very same time, Stanford was telling his investors, we're fine. Yeah, all these other banks are, you know, in turmoil, but we're healthy, we're going strong, everything's going great. So Magnus tries to cash out, and they won't let him cash out. So what do? So Magnus arranged with Stanford a series of loans, we called them sham loans, where they wouldn't let him redeem his CDs, but they quote unquote loaned him the principal and interest that he'd made, which was itself significant. And that's how he got his money out. And he got his money out in air quotes, about 90 days before the Ponzi scheme collapsed through these series of loans. So after we're appointed, the receiver's appointed and we take over, we filed a lawsuit against many, many people who cashed out, including Magnus. And we sued to recover not only his profit, but the principal as well. And we sued under the Texas fraudulent transfer statute, as well as brought a claim for unjust enrichment. 2016, the court awards us summary judgment on the net winnings on his profit. So we won that part of the case on summary judgment. He actually paid that. Then we went to trial in 2017 on the recovery of the rest, his so-called principal. We argued that the loans were fraudulent transfers. The court ended up ruling in our favor. Yes, they are fraudulent transfers. So the trial was really all about his defense, his affirmative defense under the fraudulent transfer statute, which is good faith. He had to show good faith. And we argued that, he didn't have good faith because he was essentially tipped off. And that's why he withdrew the money through these loans. And that defeated his defense of good faith. His argument was, I wasn't suspicious. I had other reasons to withdraw the money. I had other reasons to get the loans, this, that, and the other. I wasn't suspicious. I didn't know. That was his defense. So that was the trial in a nutshell over his defense. It was sort of a, what did he know and when did he know it and what did he do question that really hung over the trial.
In his example, the court is requiring him to do some due diligence and penalizing him for not doing due diligence. But if he had done the due diligence in October of 2008, he would have found that it was a Ponzi scheme. So he already invested his money. I mean, he loses either way, whether he does due diligence or not. The only way he wins if he does due diligence and turns out not to be a Ponzi scheme. But in this situation, if he did the due diligence, it wouldn't have helped him.
So there was a debate, two levels of debate, right? So the first level of debate is he says, it really doesn't matter that I didn't investigate because any investigation would have been futile. I never could have figured out this was a Ponzi scheme. And he pointed to, well, look, the DOJ didn't figure it out and the SEC didn't figure it out. And he had all these arguments about that. This futility defense actually arises out of the bankruptcy code. There's a In re Bayou something or other case that I think this comes from, a bankruptcy decision. We contended that under Texas law, there is no futility defense. If you're on inquiry notice, you have to investigate. That's just the law. So we had to take a side trip to the Texas Supreme Court after the trial to get that established, because of course at trial, the jury found he was on inquiry notice, but the judge gave him this futility question, which the jury answered in his favor. And so we come out of the district court where judgment in favor of Magnus. We had to go to the Fifth Circuit. Fifth Circuit reversed in our favor the first time, but then on rehearing sent it over to the Texas Supreme Court, which clarified you have to investigate. You have to do an investigation. An investigation is the question in our case was not what constitutes a diligent investigation. That's going to have to be explored in future cases. Because, our view was while he was on inquiry notice, Magnus didn't do anything. He was busy taking the money out. He was not busy investigating anything. But the standard, I think, is really what's going to have to guide people, at least under the Texas statute, which is good faith means honesty in fact, reasonable under the facts and circumstances, and free of willful ignorance. So whatever your investigation is, it's going to have to meet that standard. Now, you raised the point, well, what if he'd investigated and figured out it was a Ponzi scheme? Well, now he's on actual notice and it's game over. But I don't think it's quite the damned if you do, damned if you don't kind of situation. There could be circumstances where you do conduct a reasonable inquiry and your suspicions are allayed. You check here, you check there, and it all seems to be fine. Turns out later it really was a fraud scheme, but you took reasonable steps to allay your suspicions. So I think it's still a very meaningful defense. It's not an empty defense. What it'll be under the specific facts, every case will be different. Here it's a little different because the jury found he was on inquiry notice for a period of time that he wasn't investigating anything. He was just really busy getting his money back.
Why was he on inquiry notice? What are the facts that give rise to inquiry notice?
So there's probably three different categories of evidence. One is there were a lot of red flags about the whole Stanford investment scheme that would put a sophisticated investor like Magnus. Magnus is a billionaire. He's got access to financial advisors. He's not some, like day trader or something. Plenty of red flags about the way Stanford was running his bank that
like what? Are you talking about newspaper articles, lawsuits?
No, just the way it was set up. So you have an offshore bank issuing CDs, paying rates that are double and triple US. It's all according to a secret investment formula that he won't tell you what it is, and he's able to beat the market year in and year out. And the returns are steady Eddie. I mean, they're like 11%, 12, that kind of stuff.
It's too good to be true.
Too good to be true. Exactly. So there was all of that was right in front of Magnus. But of course, for years, Magnus was making money, these double-digit returns. And it's like, well, that's cool. Why get worried about it? Well, 2008, things start to be a little different. So there's that kind of red flag. The second really different category of evidence I've already talked about, which is he tried to redeem and they told him no, and they told him why. And that was information that it's beyond red flag. To us, we argued it was actual notice. You go to the bank to withdraw your money and the bank says, I'm sorry, you can't have your money, but I'll loan it to you because things are kind of iffy around here. I mean, we argued that was actual notice. So
it was game over when they said that, according to you.
I think it was game over. The third piece of evidence was his tax returns. So after the whole mess collapsed, he had to explain to the IRS why all that money that he withdrew, including his net winnings and interest, wasn't taxable. Well, what he told the IRS in his tax filings for the year 2008, which of course he filed later, he said, well, I was worried about my investment and that's why I withdrew it. Well, that was totally contrary to what he argued and testified to the jury, which is he wasn't worried about it, that he had all these other reasons. So, he told one story to the IRS, told a different story to the jury. So I think there were really three different types of evidence that the jury had in front of them. And again, they said he was on inquiry notice, that it was a Ponzi scheme. That's pretty significant.
What could he have done that would have gotten him off the hook as far as diligent investigation?
Once they told him, we can't let you have your money because things are shaky. To me, that is game over, right? The bank is a fraud at that point, and okay, you're stuck. That's just the way the law is.
Well, let's say that never happened. Let's say he's getting this too good to be true stuff. Let's say that didn't happen. What kind of inquiry could he have done?
Well, so for us, the question that he never really pressed hard to get the answer to is, tell me how you make these returns. You say that you are invested in equities and metals and derivatives. Okay, well, so is everybody else. How are you able to do the double digit year in and year out when the really smart guys at Goldman Sachs can't even do that? And he didn't, and so you would ask that question and you would press for an answer. And if you got an answer that was facially plausible, not just smoke and mirrors, that might go a long way to satisfying your diligent inquiry. But if you ask the question and the answer comes back, well, it's a secret sauce and I can't tell you how we do it. Well, that's probably not very diligent if you just accept that at face value as an answer. So I think the obligation is to press. How hard do you have to press? How many times do you have to ask the question? It's going to depend, and lawyers like complexity, right? That's how we get paid. And so it's going to be dependent upon the facts of a particular case. But, going back to what the Texas Supreme Court said is you have to be free of willful ignorance. If you're invested in this stuff and you're making these too good to be true returns, and you ask, hey, tell me how you're doing this. And the guy says, hey, it's a secret, I can't tell you. Well, there's your willful ignorance, right? See no evil, hear no evil. I'm just happy with my returns. So I think that sums it up.
I want to ask you this. So this was decided by a federal court of appeals court, applying a Texas essentially a Texas statute. Tough
Yes.
stuff. What precedential value does this have for bankruptcy cases brought under 548? Or, or does it, I'm a little confused as to the precedents there. I want your opinion on that.
Well, it's a very good question, because just like there was a single bankruptcy court case that defendants like Magnus use for this futility defense. It's not binding on anybody, but they say, hey, look at this well-reasoned opinion that, dreams up this futility defense. Here we have a statement by the highest court of exactly what the standard is. Now, there are ways that fraudulent transfer claims under the bankruptcy code and state fraudulent transfer claims, some of those elements are similar, some of those elements are different. Many statutes, like the Texas statute, either by the statute or the case law, encourage the state courts to look to the bankruptcy code for guidance. And I think there's a little bit of that, vice versa going on, because as you know, under the bankruptcy code, a trustee has the ability to bring what I would call a pure bankruptcy fraudulent transfer claim, but it can also rely on state law fraudulent transfer cases. So I think it has pretty powerful, certainly it has a controlling effect for someone suing under the Texas statute, whether in state or federal court. But I certainly think that if you're litigating in Minnesota or New Jersey or New York, and there's an open question about, futility defense and diligence, this is now a case you can point to say, well, this is what the nice folks in Texas think about that issue. Because there isn't circuit precedent, federal circuit precedent at this level of granularity on this issue.
What about the Uniform Fraudulent Transfer Act that a lot of, I think there are 40 or more states that have adopted that. Would this be, my experience typically is that when trustees sue under 548, they also sue under the relevant state statute.
Sure.
So I'm thinking that this would have even more presidential value in circumstances where trustees are applying a different state Uniform Fraudulent Transfer Act law. What do you think about that?
Well, I agree, and for similar reasons, that this isn't an issue that has been litigated to death in the appellate courts. The whole issue of the futility defense and is there a specific requirement of investigation if you're on inquiry notice. So it's not like there's 100 cases out there that you could point to. So, but now there is one from the highest court of one of the states that you can point to. And I'll give you another example. There is a debate about whether in a fraudulent transfer context, there is a so-called Ponzi scheme presumption. That is, all transfers from a Ponzi scheme are presumptively made with actual intent to defraud. We believe that that's good law, that there is. But for example, the Minnesota State Supreme Court says there's no such thing as a Ponzi scheme presumption. It's just because it came from a Ponzi scheme doesn't mean it's made with actual intent to defraud. So there's an example of, again, a state Supreme Court. That case was cited against us. It's been cited in other contexts, where these decisions on state fraudulent transfer law by the highest court in whatever state it is, they're going to be cited in bankruptcy, they're going to be cited in federal court, they're going to be cited in a lot of other contexts.
Anything that you want to say specifically about this case?
Well, for our receivership, which is now 12 years ongoing, we've got 18,000 victims. This is one of the most important recoveries for our victims for the receivership. And the team effort that went into this was just tremendous. And if you think about it, we had summary judgment on part of the case. We had a jury trial, go to the Fifth Circuit, win, then go to the Texas Supreme Court, then back to the Fifth Circuit, win again. Of course, there's always the possibility Mr. Magnus could go to the U.S. Supreme Court. He's still got time to do that. So it was a tremendous win. And, the judgment in this case is going to be, with attorney's fees and interest, in excess of $130 million. And so it's probably going to be the largest fraudulent transfer recovery, certainly under the Texas statute, that I'm aware of.
Does the defendant have a claim against the estate? I mean, it sounded almost a ruling like a bad faith ruling. Is he going to have a claim? Does he have a 502? Well, no, it's a state law. It's not a bankruptcy fraudulent conveyance. So what kind of claim does he have with the receivership?
Yeah, so in our receivership, we have a claims and distribution process that, it would be the parallel in the bankruptcy code. But the bar date for claims passed about 9 years ago. So it's a little late to be filing a claim.
Are you serious?
I am serious. 2012 was the bar date. Got to get your claim in by 2012.
So he's not going to have a claim?
No.
Wow. Well, he's a billionaire. He can afford this, right?
There are people for whom I feel sorry, but not him. The substantive case is over. The Fifth Circuit reversed and rendered judgment in our favor. So the issues on remand are attorney's fees and interest.
With this money, the payout's going to be a much larger percentage, I guess.
Yeah, so we've got just under $5 billion in claims in total among 18,000 victims. So, you do the math, what a $130 million recovery would get you. But, unlike the Madoff fraud, and this is something I've said to people, I consider the Madoff fraud kind of a Central Park fraud. He cheated a bunch of rich people and a bunch of feeder funds. Stanford was totally different. Stanford was primarily a blue collar fraud because Stanford used essentially a broker's sales force to go out and sell his phony CDs. And so while Magnus is a billionaire, he's really kind of unique in the sense of how much money he had in. The average Stanford investor lost somewhere around $250,000, $300,000. And, it's mostly people who were talked into converting their 401k or, stuff like that. It's just really awful. It's just
painful.
Oh, it's just, and as you know, in these Ponzi schemes, Madoff is the exception because the DOJ recovered, billions of dollars and, even got $1 billion out of Chase. We didn't have that. The money was mostly gone by the time we showed up.
So, in your opinion, why is this a fair outcome? I mean, you've already said that in a number of different ways, but I think that should be my last question. Why is this fair?
Well, I think it is a fair outcome because, as I said, this is tantamount to an insider trading case. Magnus cashed out based on inside information that all the other investors didn't have. What was that inside information? That Stanford was telling a lie, that his bank wasn't healthy, that they weren't doing great, and that is how Magnus was able to cash out 90 days before the collapse. And so, to me, it's no different than the guy who trades on inside information, not necessarily to make a profit, but to avoid a huge loss. The company's about to announce that some product they were going to introduce is not going to make it. And, he sells before the stock tanks. Well, I mean, this is kind of like that, right?
And somebody buys that stock. So that's
somebody buys that stock and gets screwed. And remember, there was a lot of talk at trial, and I even slip into it sometimes about talking about Magnus getting his money out. Well, fact of the matter is the money that was used to make those loans to Magnus wasn't Magnus's money. It came from the more recent investors because, of course, the Ponzi scheme was hopelessly insolvent. So, he was cashing out with other people's money. That's why it's fair.
Great interview, Kevin. I really appreciate it. A lot of fun.
Well, thank you for the opportunity. I appreciate it. It's a great case and good outcome. Thank you for doing it.
My pleasure. Thank you so much.